This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about restitution and why it is required whenever a felon is convicted of a material crime, including insurance fraud, and why restitution must be ordered even when the criminal is sentenced to a long sentence in prison. James Succi appealed pro se, that is, acting as his own lawyer, from the order dismissing his motion to vacate restitution sentencing. In Commonwealth of Pennsylvania versus Succi, a February 28, 2023 decision of the Superior Court of Pennsylvania, that court gave consideration to the pro se motions of the convicted felon, although he probably wasn't entitled to much consideration. In a prior appeal, a panel of the Pennsylvania Superior Court summarized the facts leading to the underlying convictions as follows. Succi was a residential and commercial contractor. Beginning in 2005 and continuing through 2013, Succi entered into 13 contracts to build, remodel, or construct additions on certain properties located in Bucks County, Pennsylvania, Philadelphia County, Pennsylvania, and Margate, New Jersey. In each instance, Succi either failed to finish the work, failed to obtain necessary permits, failed to perform under the contract, claimed he was insured when he was not, or provided fraudulent receipts. It was also typical for Succi to quote a price for a particular project and then increase the costs. If the homeowner challenged Succi's work practices, he threatened them with legal proceedings that would financially cripple the homeowners. In at least 2 instances, Succi placed mechanic liens on homeowners' properties. Succi was charged with multiple counts of home improvement fraud, theft by deception, and deceptive business practices, and 1 count of insurance fraud. Succi was convicted of 12 counts each of deceptive business practices and theft by deception, 2 counts of home improvement fraud, and 1 count of insurance fraud. At his sentencing hearing, the hearing proceeded with victim impact testimony presented by the Commonwealth and character evidence presented by Succi. The trial court sentenced Succi to an aggregate term of 15 to 30 years imprisonment, imposing consecutive sentences with respect to each victim. After announcing the sentence for each criminal conviction, the court imposed restitution as requested by the Commonwealth. Succi filed a direct appeal and argued 1. Several convictions were barred by the statute of limitations. 2. Jurisdiction and venue in the Bucks County Court of Common Pleas was improper. And 3. The life sentence imposed by the trial court was unconstitutional and illegal. The appellate court affirmed the judgment of sentence, and the Pennsylvania Supreme Court denied allocatur review. The trial court on this pro se motion entered an order denying Succi relief. The court explained that it considered Succi's motion to be a second untimely PCRA petition, and it had no jurisdiction to address Succi's claim. Whether a PCRA petition or not, restitution is governed by state statute that mandates that a trial court shall order full restitution regardless of the current financial resources of the defendant, so as to provide the victim with the fullest compensation for the loss. The statute further requires that the courts specify the amount and method of restitution at the time of sentencing. The crux of Succi's claim is that the trial court did not impose restitution at the time of his sentencing as required by statute. After announcing the prison terms imposed for the crimes against each victim, the trial court admitted the Commonwealth sentencing exhibits, which detailed the restitution requested for each victim. The court noted that if it believed Succi could repay the victims, it would have entered a different sentence, presumably with a shorter prison term. Therefore, Succi's claim that the court did not impose restitution at the time of his sentencing hearing was simply incorrect. Moreover, the May 20, 2015 order, which Succi claims the court belatedly and without conducting a hearing added restitution to his sentence, makes no mention of any restitution amounts which had been set at sentencing, and therefore the trial court's order was affirmed. In my opinion, victims of crime must make certain that the state prosecutor, after convicting the criminal like Succi, must demand restitution. This is really important for insurance companies because it is a way of getting back the money they paid out to honest victims of crime. The victims did so in this case, and the prosecutor effectively obtained at sentencing an order of restitution. Succi, sentenced to many years in prison, may never be able to pay the ordered restitution unless there are assets that can be taken to pay the restitution. Regardless, convicted felons have nothing but time. So Mr. Succi wasted the appellate court's time by bringing the pro se motion, which failed. He will remain in the Gray Bar Hotel for the next 15 to 30 years. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can also subscribe to this video at rumble.com or at youtube.com. If you found the blog to be useful to you, please view the videos and click on the like button at YouTube or the Rumble button at Rumble, and tell your friends and colleagues about the blog so that they can also subscribe and find available the more than 4,500 blog postings and the more than 650 videos on rumble.com. And if you found this useful, you might also consider subscribing to my Locals community or my Substack publications, where for a small fee you will receive additional, detailed, useful insurance claims, insurance law, and insurance fraud publications. Thank you for your attention.